Senator Huff. Senator Pan.
More of a comment. We got a late-breaking opposition from the American Heart Association.
Yes.
We hadn't seen that before. And from the testimony on that and the other opposition that seemed to be focusing on the obesity crisis, well, I would stipulate that we already have 400 minutes over 10 days stipulated. We have obesity. That's not solving the problem. I think we all agree from our own lives and experience that when we have lifestyle changes, that's the best thing. I didn't notice an obese kid at all coming up here to the podium earlier. And they have lifestyles that keeps them very active, that pulls them in. And I think that's, rather than focusing on inputs, we should be focusing on what motivates people, what gets them engaged, what gets them to that level of activity that keeps us lean and not obese. And I think that, you know, having been in a marching band myself and kids in a marching band, I would argue that that qualifies. And we've already made that something that fits in with the physical education. And I get that there's some physical education teachers that feel passionately about their positions, but that doesn't mean that's the only way to keep people healthy and to learn lifestyles that encourage healthy choices. And I would stipulate also that I grew up in ag community, and those that were involved in rodeo and similar kinds of activities, they did create those lifestyles. I followed them over the years. We had a barrel racing state champ in our community, and she's still a lean, fit, active person. You know, so I support you for bringing this forward, Senator Fuller. You know, sometimes we get so trapped in our little boxes of thinking what is the accurate thing. We don't look at what is necessary. And anyway, I think it's a good bill. I'll be supporting it.
Senator Pan.
Thank you. You know, I appreciate, Senator Fuller, you bringing this bill and the people who testified, but I do have concerns, I think, that as indicated in analysis, is that we don't start defining exceptions instead of setting what the standard should be in terms of what's the nature, and hopefully we can have high school rodeo fit within that. But instead of saying high school rodeo, and I realize there might be some other things in statute, because this is really about what, you know, what is the goal of the curriculum. It's part of the curriculum, right? It's part of the curriculum. As someone who's ran an educational program myself, I know you were superintendent and a teacher and so forth. What you want to do is say, this is what you need to learn and do, and if we can do it through rodeo, we can do it through whatever else, let's figure out how we can incorporate that. But I mean, one of the things I'm concerned about looking at the language is just as high school rodeo. There's no standard attached to that. So, and I know we have an association that sets some great standards, and I see some really great kids who are involved in that. But it doesn't say it has to be through the association or who's defining it and so forth. And I think instead it's better off if we can say, this is what we think physical education be involved, and, you know, set the standard, and let's find which agency's responsible for doing the details, because and say that, you know, and if you can fit, if you meet all the definitions, and if it's through rodeo or through golf or marching band or whatever else, then fine. If you don't, then it doesn't fit, and to set those guidelines. So I think I appreciate what you're doing, trying to do here, and all the young people in the association. But I think that I don't feel comfortable being able to say, I'm just going to carve out an exception for something that's not specifically defined. And instead, I think it's a better approach to set a standard for what we think should happen in physical education. Say, if you can fit in that standard, then of course that counts.
Can I explain the alternative?
An alternative?
The alternative.
The alternative.
If students, high schools do not know if they can define this as interscholastic, the only alternative for the students, if they want to be a top performer, is to go on independent study. And I don't know if you know what independent study is, but you do, okay. But for those of you who don't know what independent study is that's where an instructor meets with the student once a week and signs off all the work and gives you all the credits and things. It penalizes you if you try to go to a college. It penalizes your actual educational opportunities because you don't get to be with other kids. This is what kids that are trying to be movie stars and that are trying to go to the Olympics and things, that's what they have to use. So this is that window in between. They want to stay in their regular programs, but they want to have as much time to practice during the season as they can with excused absences without having to go on independent study. So needed to bring that up so you would know that, also the school board has to look at the criteria themselves and decide if the criteria matches what they believe their PE program is, and if it's important enough in their community. And maybe they don't have a lot of students, and maybe an independent study is the only thing they want to offer, and the school board would still have that opportunity. But for me, I hate to see that limitation. Thank you.
Okay, you're raising more questions here. Dr. Pan, you want to finish this?
Yeah, just to clarify, the existing law does give considerable discretion to the local
Right,
school
it does.
district, right? Okay.
Senator Hancock and then Senator Leyva. Senator Block.
Yeah, thank you very much. I am going to be supporting this bill today, and there are a number of reasons for that. One is I do think rodeo qualifies as a physical activity. I happen to have a very good friend who engages in team pinning as a senior in her local rodeos. And I will tell you, you practice all the time, and you're very fit if you do that, and you have a love of adventure, very much like other kinds of sports that truly test you. I understand where Senator Pan is coming from, and I think maybe we ought to look at the whole array of
right.
other things and set standards at
Right.
some point. But the other thing is it allowed now? That big question. And I have to tell you, I've carried bills in other areas. I carried a bill on earthquake safety that I thought was totally unnecessary, but our earthquake coordinator in my district wanted me to carry it. And so I did, and we passed it. And for the next 3 or 4 years, planners would come up to me and say, "Oh, thank you. It clarified that you could do something that it seemed to me you could do." So sometimes just saying it's okay opens a lot of doors for people. And in this case, because I think it is a good physical activity, I think that we should make clear that it's allowed while we work on that larger set of issues.
Senator Leyva.
Good morning. I too will be supporting the bill. When I was in high school, I was on the dance team, and I was not given an exception. So I took an hour of PE every day and practiced 2 hours after school every day, and it was hard to get my homework done. So it's quite obvious by the folks that are here today that they are very physically fit. I could not be a rodeo rider. I would not do well there, but I think it's important that we clarify, as Senator Hancock said, what is acceptable. And it's clear that these students not only can then meet their academic requirements, but they can also go on to achieve great things. And I would hate to see any of them on independent study, because that's not the full high school experience.
Senator Block.
Thank you, Madam Chair. As a former school board member, I think it's really important to give the local district clear guidance as to what they may or may not do. And to the extent, I know in the analysis it said this bill's not needed because they already have that power, but from what I've heard today, there doesn't seem to be complete clarity that school districts have that power. I'm not coming down on the side of allowing rodeo, or for that matter, dance or cheerleading or ROTC to count as an exemption to PE, but I am coming down on the side of letting our local district boards, our local elected boards decide that, and we as a state should make it clear that they have that power, so I'll be supporting this bill too.
Okay. Senator Vidak, do you have? I'd like to move the bill. Okay. All right. But this does open up a can of worms, so to speak. And on page 3 of the analysis, it does talk about a larger conversation that Dr. Pan referred to in terms of establishing standards. And that's, and you heard from the members that they want to support the young people, et cetera. But it does lead to a better understanding about what physical education is and setting standards for all the plethora of other kinds of activities that kids get involved in, and interweaving all of these things into physical education. And So it is, for me, a work in progress. This bill is going to the floor. It does not go to another committee. It's not appropriation. So with that, I would hope that we can send some kind of message that somebody from CDE should be looking at this kind of conundrum of people coming before us all the time asking for exemptions. So with that, I will entertain a motion, and I am not going to be supportive. I'm just going to leave it as your call. So
And
that's
I would be happy to
my-
work with you, Carol, on that,
okay. I would,
because I totally appreciate PE standards.
yes. Okay, thank you. Thank you. Bill has been moved, so please call the roll.
Do pass to the floor. Lou? Huff? Huff, aye. Block? Block, aye. Hancock? Hancock, aye. Leyva? Leyva, aye. Mendoza? Pan? Vidak? Vidak, aye. That's 5.
You have 5 votes, sufficient for passage. We'll see you on the floor.
And thank you, and I'd be very happy to continue this conversation.
Thank you very much. Okay, we have Senator Jackson with item number 6.
There's some amendments for your vote. She's going to acknowledge that she's going to continue working on the language to make sure it doesn't retroactively apply.
SB 186.
She'll make a statement.
Okay, thank you, please.
Thank you,
Welcome.
Madam Chair and members. This is a bill to clarify as well on a slightly different topic. This is a measure that is part of my continuing commitment to address student sexual assault on our college campuses. According to the Department of Justice, 1 in 5 college women experience rape or attempted rape during their time as a student, and this statistic represents less than 5% of rapes and attempted rapes that are actually reported. A 2014 report released by the White House Council on Women and Girls states students experience some of the highest rates of sexual assault. This violence and the stress, the fear, and mental health challenges that often follow combine to increase dropout rates and limit opportunities for success in college for women and girls. Now, while college campuses cannot hold perpetrators of sexual assault criminally liable for their behavior, that is something that goes to the criminal justice system. They do have the ability, however, to discipline students through their established student code of conduct and Title IX authorities. But despite federal and state laws that require specific prevention education, reporting, and response activities, there is in existence a current provision in Title V of the California Education Code that community colleges believe prevents them from having the same tools to discipline students for conduct in Title IX violations as schools within the University of California and the California State University system. Now, in those systems, students are liable for sexual assault and sexual battery violations that occur off campus, regardless of whether or not the victim is a, I want to say fellow student, but there's got to be a better word for that, sister student, perhaps. Community college leaders have expressed their concern to me directly that they need to have a tool in place to keep their communities and students safe. And now SB 186 is presented to align the authority of community colleges in order to hold students accountable for sexual assault and sexual battery, similar to the authority that is available within the UC and CSU system. This measure will improve the ability of California community colleges to enforce student codes of conduct in 2 critical ways. First, community colleges have the authority to suspend or expel a student for good cause. This measure expands the definition of good cause to include sexual assault and sexual battery. Second, community colleges believe they do not currently have the authority to remove, suspend, or expel a student for behavior that does not occur on campus or at a campus-related event. This measure removes that prohibition or the lack of clarity. In fact, this will give them the authority to take action for off-campus behavior and on events that are not necessarily sanctioned by the school. Title V in the California Education Code also creates confusion for community college district in terms of federal Title IX requirements. And this confusion has apparently prevented campuses, or at least from their stated point of view, prevented them from taking disciplinary action and sanctioning students for Title IX violations because of this appearance of a conflict between state and federal law in terms of off-campus jurisdiction for sexual misconduct. Now, there was some concern of retroactivity. This bill is not retroactive, not intended to be, and if I have to clarify that with additional language, I will do that. It is not intended to prevent prospective students from enrolling in a community college based upon past conduct or a past criminal conviction. This is for behavior while they're students at our community colleges, or behavior during the period of time that they are students and are thus deemed to present a threat to the campus environment. So, again, as I mentioned, it is not my intention to apply this retroactively, and we will certainly develop clarifying language to that effect if it's deemed necessary. And I would, on that basis, ask for your aye vote and have with me today witnesses who will testify as to the importance of this measure as well.
Thank you very much. In support of the bill.
Hello, good morning. My name is Cassara Williams. I'm an attorney at Equal Rights Advocates, which is a nonprofit that has led the nation in efforts to give girls a fair chance to succeed at school and at work. For years, we have been at the forefront of efforts to stop sexual harassment and sexual violence against women, and we have represented multiple students who have been sexually harassed, sexually assaulted, discriminated, and retaliated against at school. ERA uses litigation, legislative advocacy, and public education to help women and girls to inform them of their rights and protections under the law. We have a nationwide toll-free hotline, and as the lead education equity attorney, I hear from students all over the country, K through 12, community colleges, and four-year universities, and the calls and the issues that I hear about are the same, whether they go to a four-year university or community college. I'm sure, as everyone knows, as Senator Jackson pointed out, we've learned that 1 in 5 or 20% of young women in college will be sexually assaulted, which means that next year there'll be 100,000 women that will be sexually assaulted across universities. The number is clearly staggering, and it's probably even higher due to underreporting. There are more than 2 million community college students in California, and female community college students are no doubt faced with the same challenges that four-year students are faced with. In 2014, as many of you know, the California State Auditor reviewed policies of the four-year universities, including CSUs and UCs, and found out that staff members were not properly trained on how to respond to issues of sexual assault, and they were not doing enough to inform their students of their rights. I believe that this same challenges are being faced by community college students as well. What a lot of people don't realize is that currently CSU and UCs, their authority to punish students who have committed acts of sexual assault and sexual violence off campus and to non-students, they currently have that ability to do so. And as it stands now, community colleges do not. These community college students are facing the same issues that four-year universities are facing, and they should be treated the same. Title V of the California Education Code, as Senator Jackson stated, creates confusion for community colleges. The provision, Section 76034 states that no student shall be removed, suspended, or expelled unless the conduct for which the student is disciplined is related to a college activity or college attendance. When taken literally, many of the schools feel that they cannot punish a student who has committed a sexual assault off campus or to a non-student. And community college representatives, while they are required to go through Title IX training, they feel that they cannot then suspend these students that have committed the same acts. Community colleges need to have the ability to sanction the student under the code of conduct if the violation of sexual misconduct then creates a hostile environment back on campus. And while extending these acts to off-campus and even to non-students may not seem intuitive to everyone, I would like to note that 90% of campus rapes are committed by repeat offenders. So even though these proposed amendments to the Education Code will extend the assaults to non-students, this will provide additional protections for the students because community colleges will be able to commence disciplinary actions against potentially predatory students. There have been other recent calls for community colleges to implement the same procedures to prevent sexual assault and sexual harassment on their campuses, and this should be no different. Preventing sexual harassment and assault on college campuses should be a priority for all schools, K through 12, community colleges, and universities. SB 186 seeks to add additional tools for helping community colleges, and ERA supports this bill.
Thank you. Please.
Justin Selnick from the California Community Colleges Chancellor's Office.
Is your red button on? Yep, okay.
Okay.
Bring it closer. Thank you.
Okay. We don't have a formal position on the bill yet, but we've been working very closely with the author's office, and we're very comfortable with where the bill is going. We've heard from colleges seeking the same clarification as to being able to comply with federal law. So we look forward to keep working with the author on it.
Okay, thank you.
Good morning, Madam Chair and members. Jason Murphy on behalf of the University of California. We do not have a position on this bill. However, we did want to rise today to at least underscore and concur with the Senator's suggestion that we do have broad discretion within the University of California to extend jurisdiction to off-campus situations, including with non-students. So we are working hard to deal with a lot of issues that remain within the University of California, but we're lucky to say this is not one.
Okay, thank you. Thank you very much. Are there any folks opposed to this bill? We didn't receive anything in writing. Are there any questions from members? Any questions for Senator Jackson? Senator Huff.
Good morning.
I think you've identified an issue that is certainly more prevalent and rampant on colleges than what we would care to admit as a society. And so trying to figure out how to handle it in a way that is sensitive, productive, but protects due process, I think is certainly something we can all agree with. I am concerned that you don't have a definition of sexual assault in there, and I was wondering if you'd be willing to put any definition. And the reason is I'm concerned that if it's overly vague, then it invites perhaps capricious accusations.
Well, I'm certainly happy to further elucidate what sexual assault is. We do have definitions within the criminal code. There are definitions of sexual misconduct, and I'm certainly happy to expand upon that. The goal here is not to entrap anyone. It's to prevent the behavior and punish the behavior if it does take place. And the punishment that we're looking for here, as is mentioned with our University of California and our CSUs, is to remove these people from campus so that they do not do not create a hostile environment for students on those campuses. So there's no criminal proceeding that is measured here. We're talking about, as you mentioned, due process according to the school's disciplinary proceedings, which would then result, if there's a determination by a preponderance of the evidence that this offense occurred, that discipline could be taken and will be taken, hopefully, to prevent this kind of behavior and to relieve the campus from being a hostile area for its students.
You touched on some of the other issues that I do have concerns with, though, because it requires no more than, so we don't have sexual assault defined. When you say there's criminal, in the criminal code we have definitions, but we're not dealing with the criminal code here, so there should be some definition within here so we understand it. You also talk that, because it's not criminal, it's a sort of a college discipline. So there's no requirement that the police even be notified, and yet sexual assault is a very serious offense, and I think should be treated that way. So you could have an accusation that triggers something, so there's that part of it. But the accusations, I think, should also be made under penalty of perjury, or subject to criminal or civil law. And so it seems like you're trying to treat this as an infraction as opposed to something serious, right? So it's a college will take care of it, yet we have a civil and criminal code set up to deal with these kind of situations. So I guess I'm trying to figure out why aren't we dealing with it in a way that strengthens and clarifies for the colleges how to report or how to get it into the criminal system, because that's what it really is.
Well, that's not what this bill is about, Senator. What we've discovered is that a number of victims do not want to proceed through the criminal process, sadly, in my opinion. But it's very difficult to get a conviction for rape, for sexual assault, and what we're trying to do here is work on a different level. The level is to remove these people from the college campus, from the community college, the CSU campus, the university campus, so that they can no longer create a hostile area, and there is some technical language here that I'm not recalling at the moment. But the goal here is not to result in a criminal proceeding, although if the victim wants to proceed, there's nothing that precludes him or her from doing so. In fact, some of us would encourage that, would like to see perpetrators of these offenses treated harshly through the criminal justice system, but that's not what this bill is about. This bill certainly treats the problem very seriously, and I can assure you of that. The goal is to remove those people from the college campus, to punish that behavior by removing them from the privilege of being a participant in our community college system. These are our student scholars, and they need to behave accordingly. The proceedings that are being developed are proceedings that exist and are being developed by the college themselves. We do give them that discretion to create their own disciplinary proceeding. Certainly, to the extent that the victim wishes to engage the police, that is not in any way discouraged. But again, these are not criminal proceedings. These acknowledge the fact that far too few people step forward when they're a victim of sexual assault or rape. We want to encourage them to step forward and to have steps taken that will remove the perpetrator from the college campus. They do not belong there. They should not be there. And this measure is designed to make sure that that is the correct result.
And I would think part of what happens when you do that is you diminish with this bill, I think, would diminish the crime of sexual assault.
Not in the least, sir. Not in the least. And I want to be quite emphatic about that. This does not diminish the crime. In fact, if we could have victims step forward, if we could be assured that the criminal justice system was sensitive to victims, we'd see a lot more of these perpetrators convicted and imprisoned. The fact of the matter is the system doesn't work that way. The fact of the matter is that young women are frequently intimidated. The fact of the matter is that juries frequently refuse to find someone guilty beyond a reasonable doubt because there's the introduction of potentially alcohol, a lack of memory, all sorts of things come forward. Frequently, these women are humiliated, and we've seen that over and over again, people who step up and try to pursue these cases. So there's nothing frivolous or diminishing of the criminal justice system. It's a reality that exists in our society, and we don't want these perpetrators on our college campuses.
Okay, and that's a very passionate reply, which I appreciate. In taking it out of the criminal code or creating a lesser way of dealing with it, then you have these students that have been accused, which is not reported to any law enforcement. It's not made under any penalty of perjury or any requirement that they be honest about it.
Well, we don't know that,
Let me
sir.
finish, please.
We don't know that,
Then
but
it would,
your assumption is false.
no, the assumption is not false because you're not requiring this. So what it means, I'm just trying to lay out what I see as some fundamental flaws, and that's my perspective. But you haven't defined what it is. There's no requirement to be made under penalty of perjury. So, you know, not that people do this willingly, but every now and then they do. And so now you have a board that is going to review this. And can you describe who makes up this review board, the disciplinary board?
The disciplinary boards are made up by each of the community colleges. They have existing boards. Under Title IX, there are provisions that are going to be taking place. Under SB 967 that was passed into law, we are developing those protocols that will be applied along all the college communities, and that certainly there has to be a showing. This isn't just someone coming forward and saying, oh, I've been sexually assaulted. These are disciplinary proceedings that our community colleges, our universities already have in place. They are fact-finding bodies as well, and there is they already have the authority in other instances to take disciplinary action. We are just expanding it, encouraging them, requiring them to take steps in order to respond to allegations of sexual assault.
So the disciplinary boards, as I understand them, be made up of college administrators, faculty, perhaps some students?
It's going to be up to each college campus to decide how they wish to proceed with these matters. There's going to have to be training. There will be parameters that are set up. This is all, the University of California has developed its own system. I don't have that handy, but I am very confident that they are going to protect the rights of both the accused and the accuser, because there are consequences if they don't.
Well, so this is developing protocols, is what you're describing, and yet we have existing, to your own testimony, existing boards on these campuses dealing with campus type of discipline. So I'm concerned also that there's no requirement for, or experience for, judicial expertise. There's no standard of the accused to cross-examine the accuser or witnesses, present evidence, no, even to be represented by counsel, and yet, as we described earlier, these are truly criminal behaviors that the school is trying to deal with in a non-criminal manner. So I am concerned that we haven't defined things, we haven't required things to be made under a penalty of perjury, the accusations. We don't have a due process set in that protects not just the accused but the accuser. And so I guess there's some fundamental issues here that I think you're dumbing down unintentionally, but in a way to capture more and to remove them from the schools. We don't have the safeties or due process set up that our criminal system has evolved to try to protect. So I fully appreciate the problem that you're describing, and I agree with you. I think that without some more defining language in here and some ways to deal with both sides of the equation, because the equations are balanced, at least, you know, in math, as I recall, that's what an equation did. But I can't support it today. I like where you're going. I won't vote no against it, but I can't support it. I would love to work with you on these issues, but it sounds like you fundamentally want to do something different that is a lesser than a criminal type of prosecution. And in doing so, I just think we need to make sure we have the checks and balances put in there that the process requires. These are serious allegations, and certainly they deserve serious repercussions.
Well, I appreciate that, Senator. I'd just like to remind you that there are different levels of proof that are required given different types of proceedings. This is not a criminal proceeding. This does not preclude there being a criminal proceeding. In fact, if we could encourage and get women who are the victims of these offenses to step forward, that would be even better. What this does is remove these people from campus. So in a criminal proceeding, we have a standard of proof beyond a reasonable doubt and to a moral certainty, because the sanctions are potentially incarceration. Here, the sanction is potentially dismissal. Different standard, different tests, different requirements, but no less requiring levels of due process as we do throughout the criminal and civil justice system. In the civil justice system, standards of proof are usually preponderance of the evidence, as high as perhaps clear and convincing evidence. In a criminal courtroom, we have the highest standard because the potential consequences are denial of one's freedom and liberty. It's a different situation here, but I would hope that as we move forward, we're able to respond so that we can not only remove people from a college campus for these offenses, but then take and move more in the criminal proceeding to sanction that behavior with the maximum that the law allows, but that's not what this bill is designed to do. It wants to remove these people from campus so that a campus is a safe place where people go to learn, and parents can be assured that their children aren't going to be potentially 1 out of 5 victims of rape on our campuses. This is an absolutely appalling statistic. It is an appalling circumstance, and for the young women who find themselves subjected to having to walk around their school campuses with the perpetrator of those offenses, it's completely unnecessary, inappropriate, and this is a bill that's going to do something about it. And with that, I'll close unless there are any other questions.
Thank you.
I did have one more comment on that, though. That's a very passionate response, and I agree again with your premise, but the problem is without even defining what it is here, then it leaves you wide open to very vague and changing across different campuses considerations of what this sexual assault is. And I think at a minimum, you have to define what it is, or we will never know what it is.
Well, we do know what it is, but I'm happy to make it clearer as we proceed, and I'll be delighted to talk with you and work with you further on that.
Senator Leyva and then Senator Vidak.
Thank you, Madam Chair. Senator Jackson, I want to thank you for bringing this bill forward. I think one of the biggest issues or problems that we have in society is that women who are raped, not sexually assaulted, I think we're dumbing it down or being a little politically correct when we say sexually assaulted. Let's say, what it is. Women who are raped don't want to go forward. They are embarrassed. They are humiliated. They think they did something wrong. They don't press charges like they should. I see your bill as a bill that gives these young women yet another avenue that maybe they feel safer and they can report this hideous crime that was done to them. And yes, they should. I agree with my colleague. They should be prosecuted. But until, and it may never happen, women who are raped always feel that they did something wrong. And until we make sure we have all the avenues available for them to report this crime, that's a start. And maybe when these young women report it at the college campus that they're at, maybe then they'll find the courage and some support, and then maybe they will report it and the crime will be taken care of. So I thank you for bringing this forward, and I will be supporting your bill today.
Thank you.
Senator Vidak.